So, without further delay, let me quickly introduce our speakers and we'll get started. We're going to begin this afternoon with a discussion of an update on some FMLA issues by Julie Reddig, particularly looking at some of the challenges and issues that arise with a hybrid and remote workforce. We'll then turn to Mark Engel, and Mark will address these changes that we're all dealing with in the DEI space and the EEOC guidance around those. Mike Neary is going to talk about changes in the EEOC and trends that we are seeing and experiencing with the claims and claim processing at the EEOC level. Nicole Berman will discuss an issue that is gaining traction across the country and has been addressed by many jurisdictions and now Maryland with the new new heat management regulations. And then Jessica will close us out by tackling the changes in the Commonwealth of Virginia around its non-compete laws. So without any further delay, I know you're anxious to hear the speakers. Julie, you have the floor.
Great. Thanks so much, Jim. I'm happy to be with you all this afternoon. Gonna bring up a small slide deck here for my portion of the presentation. There we go. Okay, so as Jim mentioned, I'm going to speak this afternoon briefly on an FMLA update. There have been a few things that have changed in the FMLA space in the recent months, and I wanted to bring those to your attention. And then a reminder on something that's always been around, but perhaps we have to apply it in a new light now that we have so many employees working on a remote basis. So I'm going to be covering three things in this brief update. A new case that illuminated an often forgotten provision of the FMLA, an opinion letter that was issued in January by the Biden administration's Federal Wage and Hour Division regarding how FMLA interacts with state paid leave laws. And then I'm going to close with a reminder of how, as I mentioned, FMLA applies to employees working remotely. So let's get started. As everyone knows, FMLA at the federal level provides leave for employees to care for the employee's spouse or parent or child with a serious health condition. But recently there is a case in the Sixth Circuit Court of Appeals, or an opinion rather, that reminded us that there can be instances where this protection actually can extend to other individuals an employee is caring for. So the Sixth Circuit Court of Appeals is the federal appellate court that includes the federal courts within Kentucky, Michigan, Ohio, and Tennessee. It's often a very pro-employer court, but as you will hear, in this case, they actually took a very pro-employee position. So let me tell you a little bit about this case. The case was brought by a female employee named Celestia. She's a finance manager at a car dealership, and the car dealership was called Midwest Auto Group, or MAG. She worked for MAG in Ohio, and she had a sister named Sharon who lived in Kentucky who had non-Hodgkin's lymphoma. Sharon learned that her disease was terminal, and she asked her sister to be her primary caregiver for her final days. So Celestia traveled to Kentucky to be with her sister. And while she was there, she paid some of Sharon's bills. She bought her groceries, she cooked her meals and fed her, helped her use the bathroom, cleaned her, brushed her hair and teeth, took care of her apartment by cleaning it. She took out the trash, did all the laundry. She administered medication to Sharon, moved her around in her bed to prevent her from getting bed sores and ensuring that she was comfortable, and generally provided her with additional emotional support. Now, during this time, she was off from work and using her accrued paid leave. After she exhausted the accrued paid leave, she asked MAG if she could take FMLA leave. And MAG told her no. The HR representative said FMLA does not provide leave for an employee to care for a sibling. Essentially, they said, you need to choose between your job or caring for your sister. They did allow her a few additional days of unpaid leave to be with her sister before reporting back to work. But they did tell her that if she wanted to maintain employment, she needed to return. So on the day of her scheduled return to work, she was running late because the person who was taking over for her for caring for her sister was delayed by their own flight. And so she texted Mag, said, explain the situation. And within an hour of that text, Mag terminated her employment. And her sister Sharon died 2 days later. So Celestia sued, bringing claims under the FMLA, along with a few other statutes. And at the trial court level, they found for the employer. And so she appealed the case to the Sixth Circuit. And I'm going to cover the FMLA piece of the court's analysis. The court said, yes, of course, FMLA does not specifically cover siblings, but it does permit employees to take leave to care for an in loco parentis parent or child. And so Celestia argued that when she asked for FMLA leave, she was actually responsible for her sister in the way that a parent would be. So she was in loco parentis to her sister. Now, the FMLA does not in itself define loco parentis or specify how or when these relationships can form. And so some of the issues are, does that relationship need to predate the period of incapacity, or can it be formed even at all between two adults? Because here, in this case, of course, the in loco parentis relationship with the sister formed when they were both adults, and it was after her sister became ill and incapacitated. So the question for the court was that sufficient to create that in loco parentis relationship? The lower court at the trial level, they said no, that can't be the case, but the Sixth Circuit disagreed and said yes. And in loco parentis relationships can be formed between adults, including adults who happen to be siblings, and they can be formed after the individual is incapacitated. And the court said there's various factors that you need to consider when determining whether that in loco parentis relationship exists, whether or not the in loco parentis parent is in close physical proximity to the adult in loco parentis child, whether the in loco parentis parent assumes responsibility to support them, whether the in loco parentis parent exercises control or has rights over the person, and whether the in loco parentis parent has a close emotional or familial bond with them akin to that of an adult child. So the court says this is not an exclusive list, not one single factor controls, but these are the types of factors that a court should look to. And so the Sixth Circuit didn't in itself apply these factors to this situation. They sent the case back down to the trial court to determine that. But I think that this case is a really important reminder to employers that there are potentially other individuals that could be, that an employee could be taken care of and for which the employer would have to provide FMLA leave. And so thinking about this, employers should really, pay attention to requests and not just automatically dismiss something because the employee is taking leave to care for an individual that doesn't fall squarely within that definition of a parent, child, or spouse. And remember that there could be this in loco parentis situation that could apply, and that the employer, can ask questions and determine that to understand the basis of the relationship before making a decision whether or not to grant FMLA. And I wanted to note too that after this case was decided, the Department of Labor issued a fact sheet giving more information on what is the in loco parentis situation under the FMLA. And so I have a link to that in the slides, and we'll share these with everyone after the session today. The second thing that I wanted to make sure all employers are up to date with here is the opinion letter that I mentioned that was issued in January prior to the end of the Biden administration by the Department of Labor's Wage and Hour Division. And the focus of this opinion letter was when an employee can or when an employer can mandate that an employee use their accrued paid leave when they are on FMLA and there is an applicable state paid leave program. So, um, as you know, a number of states and local jurisdictions have passed laws that provide for paid family medical leave benefits to employees. DC has one in place. We have one forthcoming in Maryland, again delayed, but will be in place in a few years. And so many of these paid leave programs provide leave for reasons that also qualify for leave under the federal FMLA. So the leaves often run concurrently. And the FMLA allows an employer to either require an employee or allow the employee to elect to use their employer provided paid leave benefits like vacation leave and PTO and sick leave. So the question is the same true with regard to these state paid leave programs? Now, you may remember that there is a different rule when it comes to whether or not the employer can mandate use of accrued leave when the employee is also receiving disability benefits or workers' compensation benefits concurrently with FMLA leave. In that situation, the employer can't require the employee to use that paid leave to cover the delta, right? But the employer can um, agree with the employee where the state law permits to allow them to use the accrued paid leave to supplement the workers' comp or supplement the disability, the short or long-term disability benefit. And so here, what the Department of Labor said that analysis is also what must be used whenever there's a state paid leave program in place. And so an employer cannot require that an employee use employer provided leave while taking leave under FMLA and receiving benefits from a state or local paid leave program. According to the DOL, the employer and the employee would need to mutually agree for the employee to use these provided leave to pay that delta between the benefits and their full salary. So important that you update your policies to make sure that both your FMLA policy and your paid leave program policy and use of accrued leave for FMLA purposes are revised to comply with this. And I have a link to the opinion letter on the slide here. And again, we'll circulate it after. And then just briefly, I want to cover a topic that there hasn't been anything actually super new on this, other than the fact that what has changed is the way companies and employers are working, in the sense that we have so many employees working remotely. And often I'm having conversations with employers regarding application of FMLA leave to employees who are working from home in perhaps a different state, far from where the employer's headquarters is or any office. And oftentimes the employer is telling me, oh no, they're not covered by FMLA because they live, so far away. As a reminder, to be covered by FMLA, the employee has to not only work for the employer for at least 12 months and have worked at least 1,250 hours during those 12 months, but they also have to work at a location where the employer has at least 50 employees within the 75-mile radius. But it's important to remember that the regulations actually specify that when it comes to an employee with a no fixed work site, the work site is the site to which they are assigned as their home base, or from which their work assignments are provided, or to which they report. So if there are 50 employees in any one of those sites, and the employee is, reporting to that site or receiving direction from a supervisor working at that site, then they would be covered under FMLA. So you want to make sure that you're thinking about that as you're going through your FMLA analysis, and before you deny FMLA, that you're thinking about this. I have listed on here, there was a field assistance bulletin issued in 2023 by the Department of Labor that goes through some really helpful examples, and also a case back in 2022 that decided this same issue. And so another option that you have just is that you may want to simply extend FMLA leave to all employees working remotely. So that way you don't have to go through that kind of analysis of where the employee is working and who they're reporting to and all of that to see if there's coverage for your remote workers. And with that, I'll turn it back over to Jesse.
Thank you, Julie. It looks like we do not have any questions at this point. Again, you can ask questions in the Q&A portion of your screen. And so I'm going to turn it over